I had the opportunity to speak to Ms. Hawkins about her citation. It's my understanding that she intends to accept the CU Restorative Justice Program requirement, which is in the DJS and file, required to complete the CU Restorative Justice Program, the CU Community Living class, and the assignment of course by probation and substance use screening.
Okay, thank you for all that, Mr. Altenberg. And Ms. Hawkins, this does show a deferred judgment agreement. It would be to the two charges of possession of or consumption of alcohol by someone under the age of 21 and having a fraudulent identification. You'd be pleading guilty or no contest to those two charges placed on the deferred judgment for the 9-month term. You'd be expected to complete CU Restorative Justice, the community living class, and then our probation officer will do a screen of you and order you to complete some type of substance use education program. If you went through the 9-month period without any other similar charges, at the end of the 9 months, your case could be dismissed and your record could be sealed. It sounds like that's what you'd like to do. Is that correct?
Yes, sir.
All right. When you plead guilty to these charges, you're giving up your right to trial on those charges. Do you understand that?
Mm-hmm.
Are you doing that voluntarily? Is anybody forcing you to plead guilty? Are you under the influence of any medications or drugs or alcohol?
No.
Do you understand these charges? We'll start with the charge of possession or consumption of alcohol by someone under the age of 21. You do understand that?
Yes.
And do you agree that there's evidence to support that charge?
Yes.
Okay, so you seem a little confused, but it means that if is there evidence that a police officer or somebody could come and testify that in fact you were under 21 and you possessed alcohol?
Yes.
All right. The other charge is the charge of having a fraudulent identification. Do you understand that charge?
Yes.
And do you agree that there's evidence to support that charge?
Yes.
You're doing all of this without the benefit of a lawyer to help you. If you wanted, we could continue the case over and you could hire counsel. Do you understand that?
Yes.
If you couldn't afford an attorney, I could appoint a lawyer to represent you. Or if you wanted to get reduced fee representation, you could probably go through the university. The Office of Student Legal Services offers good representation at a pretty low fee for people. So that's another option. You understand all of that?
Yes.
Are you comfortable going forward without a lawyer?
Yes.
I'm going to find that it's a free and voluntary decision for the defendant to plead guilty to these two charges on no contest. And the record does indicate that she's a University of Colorado student, so understands the rights that she's giving up. Count one is a charge of possession or consumption of alcohol by someone under the age of 21. This allegedly occurred on August 29th of 2025 at 1149 13th Street. How do you plead to that charge?
Guilty.
I'll accept that guilty plea. Count two is a charge of having a fraudulent identification, which is a violation of section 5612 of the Boulder Revised Code from that same date, time, and location. How do you plead to that charge?
Guilty.
All right, I've accepted those two guilty pleas. We're going to place you on the deferred judgment, so you do get a chance to earn a dismissal of both charges. That will happen automatically at the end of the 9-month term. We will withdraw these two guilty pleas, dismiss the charges against you, and seal your record. You've got to earn it. You got to do the things that you've promised to do here today. And that includes completing the CU Restorative Justice Program, the community living class, and then you're going to meet with probation here in just a few moments. They're going to determine the level of a substance use class for you to complete. There are $155 in deferred judgment fees. Can you pay those today?
I believe so. I
Okay.
have to call my parents.
Okay. I'll just put a note here for Fernanda or for Dara, if time needed to pay. We prefer if you pay today, but if you for some reason are not able to, then probation can make it due on the date that the class and all the other obligations are due.
Okay.
And we would waive a stay fee if that were the case. Okay, I'll point out a couple of things to individuals, anybody who's impacted by a fraudulent identification charge. I point this out for a couple of reasons. That it's very important that you not continue that type of behavior. All of the behavior you've got to stop because you're under the age of 21. But that one in particular, because you could graduate from CU, have a great degree and a great future ahead of you. And then if you end up with a fraudulent identification conviction on your record, that can be perceived in a lot of different ways. Having a fraudulent identification might be perceived by an employer as somebody who's misrepresenting who they are, which is technically what you're doing. And if they're concerned that they can't let you have access to their digital databases, that's a lot of jobs that you're excluded from. And so you have to think about what these things actually mean to others when you're making decisions to have a fake ID. And so I encourage you to not continue with that because it could end up with a conviction on your record that really impacts the rest of your life. And the other thing I would just point out is most police officers and police departments realize that people have a packet of these IDs. So they are going to continue to look for fake IDs with people, particularly ones who they've run across before. And so I would encourage you, if you have a packet of them that they sent to you when you got these, or if you got them from someone who gave you more than one, then I would say get rid of those because the temptation will be there to use a fake ID. And that a second offense here, problematic. Prosecutors aren't going to just look the other way and give you a deferred judgment. They're going to want something different from that. Does that make sense to you? And you're not the only one. I have this conversation with everybody because I don't want young people to leave here. I don't want you leaving with an alcohol or substance use problem. And I certainly don't want you leaving here with a conviction that impacts your record going forward. All right. Any questions for me?
No, sir.
All right. So why don't you just have a seat? When it's time, we'll send you back to have a conversation with our probation officer. We'll send you back in a group here in just a moment.
Thank you.
Not an easy one for either of us to say.
My apologies.
Good morning to you. And go ahead, Mr. Altenberg.
Yes, Your Honor, I had the opportunity to speak to Mr. Rosenquist about the CU Restorative Justice Program. It's my understanding that he intends to accept the DJS in file, requiring him to complete the CU Restorative Justice Program, the CU Community Living class, and the substance use screening and assignment of appropriate course by probation.
Okay, great. Thank you for that, Mr. Altenberg. And I'm going to pull up that document so we can go over it. And Mr. Rosenquist, it does show that if you enter into the deferred judgment for the two charges that are pending, possession and consumption of alcohol by someone under the age of 21 and fraudulent identification, that the prosecutor would ask me to place you on a deferred judgment. You'd have CU RJ to complete, CU Community Living class, and the substance use screening and class that's ordered by our probation department. Is that what you'd like to do?
Yes.
All right. When you do this, you're giving up your right to trial and all of the other rights that I've described to the group. Do you understand that?
Yes.
Are you doing that voluntarily?
Yes.
Is anybody forcing you to plead guilty?
No.
Are you under the influence of any medications or drugs or alcohol?
No.
Do you understand these two charges will start with possession of alcohol by someone under the age of 21? Do you understand that charge?
Yes.
And do you agree that there's evidence to support that charge?
Yes.
Do you understand the charge of having a fraudulent identification?
Yes.
And do you agree there's evidence to support that charge?
Yes.
You're doing all of this without the benefit of a lawyer. Do you understand you could hire a lawyer to represent you, or I could appoint a lawyer if you couldn't afford one?
Yes.
Are you comfortable going forward without a lawyer?
Yes.
And you're a CU student, so I assume you understand the rights that you're giving up.
Yes.
I am going to find that it's a free and voluntary decision to plead guilty. We'll start with the charge of possession of alcohol by someone under the age of 21. This allegedly occurred August 29th of 2025 at 2085 Colorado. How do you plead to that charge?
Guilty.
I'll accept that guilty plea. The other charge is a charge of having a fraudulent identification, which is a violation of section 5612 of the Boulder Revised Code from that same date, time, and location. How do you plead to that charge?
Guilty.
I'll accept those two guilty pleas. We'll place you on the deferred judgment for the 9-month term. You'll have the CU Restorative Justice Program to complete. You'll also have the community living class. And then you'll meet with probation here in just a few moments for them to determine the education program for you to complete. The job for you and for everybody else on a deferred is to make sure that you get those 3 pieces of documentation back to probation. So the community living class, you'll get a certificate. The CU RJ, you'll get a completion letter. And then the alcohol class you complete, you'll get a completion certificate. You'll want to get all 3 of those pieces of paper. You can email them, but make sure they get back to our probation department. And keep in mind that you're likely to hear from CU as well, that you might get sanctions imposed by them in connection with the Office of Judicial Conduct. You may or may not have received a text from them. You should anticipate either getting an email or a text from CU. Whatever you work out with them is separate from us. So just make sure that you respond to what they request. A lot of times they'll want to know what you've done here from the criminal case perspective. They may have you just give them proof of what we've had you do, and that may satisfy them. But if they ask you to do something in addition, you'll have to make sure that you give that to them, and make sure both sides, both CU and our court, get proof that you've completed these things. All right. And that's for everybody. I like to make sure everybody's aware of that because it can be surprising when you hear from CU. If you'll just have a seat, as soon as we're done with the other cases, we'll send you back as a group.
I had the opportunity to speak to Mr. Gillings and inform him about the CU Restorative Justice Program. It's my understanding that he intends to accept the DJS in file, requiring him to complete the CU Restorative Justice Program, the CU Community Living class, and the substance use screening and assignment of appropriate course by probation.
Okay, thank you for that, Mr. Altenberg. So, Mr. Gillings, I'll go over the same questions with you that I went over with others. First of all, I want to make sure this is what you'd like to do. Is that correct? I need you to speak out loud so I have a good record of what you're saying to the court. When you plead guilty to these two charges, you're giving up your right to trial. Are you doing that voluntarily?
Yes.
Is anybody forcing you to plead guilty?
No.
Are you under the influence of any medications or drugs or alcohol?
No.
Do you understand these two charges? I'll start with the charge of possession or consumption of alcohol by someone under the age of 21. Do you understand that charge? Do you agree there's evidence to support that charge?
Yes.
You understand the charge of having a fraudulent identification?
Yes.
And do you agree there's evidence to support that charge? You are doing all this without the benefit of a lawyer. Are you comfortable going forward without a lawyer?
Yeah.
You understand a lawyer might do a better job of representing you than you do representing yourself. I am going to find that it's a free and voluntary decision to plead guilty. Count one is a charge of possession or consumption of alcohol by someone under the age of 21. That is a violation of section 574 of the Boulder Revised Code occurring August 29th of 2025 at 2085 Colorado. How do you plead to that charge? I'll accept that guilty plea. Count two is a charge of having a fraudulent identification. That's a violation of section 5612 of the Boulder Revised Code from that same date, time, and location. How do you plead to that charge? Accept those two guilty pleas. We'll place you on the deferred judgment for the 9-month term. There'll be $155 in fees and costs. You'll have the CU Restorative Justice program to complete, the community living class, and then our probation officer will determine the substance use class for you to complete. Do you have any questions for me? All right, the key is to not get another one of these charges. If you come back, it won't be the same response from the prosecutor. So making sure that you're thoughtful about what you're doing and not ending up back in the courtroom, because like I tell everybody, the first offense, we really want to get people educated, get an understanding of what they can and cannot do. If you come back with a second offense, we're going to assume that you're not following the law purposefully and not really getting the message. And we'll also be concerned about what's going on with respect to your alcohol use. So the dive will be a lot deeper from the court and from the prosecution with the second offense. But if you don't have any questions for me, we'll just have you have this. Well, actually, let's go ahead and send these three back. And then we'll call Miss Lizzie Kamek's case back up in a little bit. But let's send Lily Hawkins, Kel Rosenquist, and Nathan Gillings. If the three of you will go back to the probation area, you're going to make two right turns on the left. Will take you all the way to probation. She'll meet with you in just a few moments, go over all of this with you, and then get you on your way.
Looks like Miguel's gonna walk back.
Oh, Miguel's going to take you back. Thank you, Miguel. And we'll recall the Angelo Rosas case. Mr. Rosas is back after speaking with Miss Keller. Go ahead, Miss Keller, if you're ready.
Thank you, Your Honor. I've had a conversation with Mr. Rosas this morning. Like you said, there are 4 charges here. Given the severity of the allegations in the report, I think the best thing to do here would be to get discovery and then have Mr. Rosas return to court at a later date. He also mentioned that this was his friend's dog, so potentially having his friend come and claim responsibility for the dog.
Okay. That all sounds reasonable to me. Is that what you'd like to do, Mr. Rosas?
Yes, sir. Yes.
Okay, and I'll just point out, well, if your friend comes with you and he's the guardian of the dog, or if it's more than one dog, it looks like perhaps just one, but if he wants to substitute as a defendant, I can tell him what that means, but he could actually take legal responsibility for the case and substitute in as the defendant. And then that would remove you from the process. I'm not saying that will or will not happen, but I wanted you to have an understanding of what that meant so you could share that information with him.
Yes.
It makes sense from the court's perspective for someone who's going to be accountable for a dog to be the person that is the defendant, but I can't force that. They've cited you because you were the alleged guardian at the time that this occurred. So, but we can reset your case. We'll reset it 2 to 3 weeks out. That'll allow the prosecutors the opportunity to send you the discovery, which is the police reports and witness statements, everything else that you'll have. So you'll have that before you come back to the next court date. No pleas will enter today. So you haven't given up any rights yet. You just, right now, it's just resetting your case.
Okay.
All right. Right out front, they'll give you that new court date in just a few minutes.
All right, thank you.
Your Honor, Mr. Rogers and I had an opportunity to talk about a little bit more about what his needs are. And we established that he was interested in a housing assessment, which I completed for him today. Also, after this, I'm going to help him schedule a mental health partners appointment in Boulder.
And was that the one home assessment that's done? Is it?
Yes, Your Honor.
Thank you for that, Sebastian. Okay, great. So, Mr. Rogers, because you participated and did that one home assessment with Sebastian, your case is now going to be dismissed.
Thank you.
And we automatically seal your record for that charge when we dismiss the case. So nothing else for you to do with us, but any work that you can do with Sebastian to help you get more stability, getting that mental health partners appointment set, those are all positives. So glad to see that you're connected with him. And any further conversation today, or is he free to go, Sebastian?
He's welcome to. He did express interest in scheduling a mental health appointment, so I'll help him with that in the hallway.
Okay, sounds good. All right.
Okay,
Thank you, Mr. Rogers. You have a good day, sir.
Thank you, Your Honor.
Under 18, is that right?
No, not anymore.
Oh, when did you turn 18?
September 9th.
Oh, okay, good. So we don't need to have someone over 18 with you. Good. I had seen that perhaps when you got the ticket, you were still under 18, but you're not any longer, so you're able to handle the case on your own. All right, go ahead, Mr. Altenberg.
Yes, Your Honor. I had the opportunity to review the citation with Ms. Lizzie O'Kimmick, and after reviewing the citation and conversation with her, the city doesn't believe we can prove beyond a reasonable doubt the charge of MIPM. As such, we have filed a motion to amend summons and complaint into the ROA tab for this case, requesting the court to remove the MIPM charge based off of the information we've determined.
Okay.
We have also re-uploaded a DJS offer, Your Honor, which is the same exact requirements, albeit without the requirement of pleading to the charge of MIPM, because we are seeking dismissal of that specific charge.
That all makes sense to me, and probably a bit of a relief for the defendant, so she doesn't have to think about the implications of the marijuana charge. So the motion to amend, I'm going to just pull that up briefly. Let me look at that. See what it's specific. So it's asking me basically to dismiss that charge. So I'm going to grant that request from the prosecutor to dismiss the marijuana possession charge. And so I will issue an order dismissing that in response to the motion to amend. And then that leaves you with just the two charges that are pending in the deferred judgment. And that is for a 9-month deferred judgment to the charge of possession of alcohol by a minor and to a charge of having a fraudulent identification, much like the other young woman we spoke to who you were kind of sitting next to during this process. So the exact same outcome that she had in her case would be required to complete the CU Restorative Justice program, the CU Community Living class, and then the substance use screen that our probation department will do. Is that what you'd like to do?
Yes.
Now, when you plead guilty to these two charges, you're giving up your right to trial and all the other rights that I've described to the group. Do you understand that?
Yes.
Are you doing that voluntarily?
Yes.
Is anybody forcing you to plead guilty?
No.
Are you under the influence of any medications or drugs or alcohol?
No.
And do you understand these two charges? I'll start with the charge of possession of or consumption of alcohol in public. Do you understand that charge?
Yes.
Do you agree there's evidence to support that charge?
Yes.
Do you understand the charge of having a fraudulent identification?
Yes.
And do you agree there's evidence to support that charge?
Yes.
You're doing all this without the benefit of a lawyer to assist you? Are you comfortable going forward without a lawyer?
Yes.
And do you understand a lawyer might do a better job of representing you than you do representing yourself?
Yes.
I am going to find that it's a free and voluntary decision to plead guilty to these two charges. Count one is a charge of possession or consumption of alcohol by someone under the age of 21 in violation of section 574 of the Boulder Revised Code. That allegedly occurred August 29th of 2025 at 1149 13th Street. How do you plead to that charge?
Guilty.
I'll accept that guilty plea. Count two is a charge of having a fraudulent identification in violation of section 5612 of the Boulder Revised Code, also allegedly occurring on August 29th of 2025 at 1149 13th Street. How do you plead to that charge?
Guilty.
Right, I've accepted those two guilty pleas to counts one and counts two. Count three is going to be dismissed. There'll be $155 in fees and costs for the deferred judgment. You'll have the CU Restorative Justice program to complete, the community living class to complete, and then you'll meet with our probation officer here in just a few moments to get the alcohol class determined for you to complete. All three of those need to be taken care of by the due date that she sets for you. If you meet that due date and you go through the 9 months without any other charges, at the end of the 9 months, we're going to withdraw the guilty pleas that have been issued today, dismiss the charges, and then seal your record.
Okay.
Any questions for me?
No,
Okay. I'll put a note here that we're gonna dismiss, and I'll do that by motion.
I just dismissed it.
Did you?
by
Okay.
The motion, just because they put it in, but we would still need your official.
Yeah, I'll sign off on that, but you've already dismissed it in there?
Mhm.
Okay.
Sorry, I should have asked you. I was
No,
just-
that's okay. I was kind of debating what the best way procedurally was to do that.
But then this way, I've also informed Ms. Bittencourt too that that was dismissed and when she looks at the
Okay.
disposition.
That's terrific. She may have heard us, but she may not have, so that's great. Okay. If you don't have any questions for me, Ms. Lizzie O'Kamick, we're gonna have you go with Miguel. He's gonna walk you back to probation, get you started with the next step of the process.
Thank you so much.
You're welcome.
There are two charges of dog at large in this case. The offer the city has extended is a deferred prosecution. The affirmative requirements here, she get no new similar charges for a 6-month period, and that she complete an animal ordinance class.
All right, let me pull that up and I can go over that with Ms. Arndt. So Ms. Arndt, a deferred prosecution does not require that you plead guilty to anything. The case stays open for 6 months. You would have a $100 deferred prosecution fee to pay for that. There wouldn't be any other fees that you'd have to pay, although the animal ordinance class that you would take they do charge a fee for that. So just be aware that you'll have a cost associated with that. Those are the obligations that you'd be expected to comply with, in addition to not having any other similar charges during the 6-month period. At the end of the 6-month period, as long as you have complied with your side of the agreement, then the case is going to be dismissed. We would automatically pull the case up, dismiss the case, and then we would seal your record associated with that charge. So just wanted you to be aware of all those consequences if you decide to accept the offer. But is that what you'd like to do?
Yes, please.
All right. So I am going to make this an order of the court. We'll place you on the deferred prosecution for the 6-month term. You'll have the remote education class to complete the animal class through CIMA.
CIMA, how do you spell that?
CIMA. You're going to meet with our probation staff here in a few minutes. You're not on probation, but you're going to meet with Fernanda so that she can get your signature on the deferred prosecution agreement. And she'll also give you the information about CIMA so that you can sign up for that class with them. It's electronic sign up and it's a remote class.
Your Honor, I just wanted to check in. Ms. Arendt shared with me that she does have to be out of here by 10:20 to go teach a class in Denver.
Okay.
So I don't know what the wait time is, but it might make sense to schedule a different time just so she can make it to her class.
This might be something that can be done remotely. I just don't know. Fernanda, are you hearing us right now, or she might be with someone?
Your Honor, I'm listening in.
Oh, Dara is. Okay, Dara, can we have this meeting right now and get her on her way, or do we need to try to schedule her?
Yeah, I can print that out and get her out of here before 10:05.
Okay, sounds good. Then
Thank
you bet. Then we'll just send you back. You're going to meet with Dara here in just a few moments. I'm making this an order of the court for the $100 deferred prosecution fee. You'll take care of paying that today. She'll give you information about the class and get you on your way. So Miguel, would you mind walking Ms. Arndt back to Dara and get her on her way? Thank you, Ms. Arndt.
Thank you.
And whenever you're ready, Mr. Altenberg.
Yes, I had the opportunity to speak to Mr. Cooper about his citation and the allegations within it. We have offered him a deferred prosecution, a requirement of him completing 3 hours of community service, of which we do intend on filing shortly. Although, Your Honor, it's my belief that Mr. Cooper intends to plead not guilty and set this case for trial. And we do like to request the court to permit virtual appearance for Mr. Cooper and any parties for trial, should it go to trial. As Mr. Cooper has informed us that he is an out-of-state resident and he doesn't intend on being in Colorado within the next 1 or 2 weeks.
Okay. And the trial will probably be quite further out than that in a few weeks, but you're not going to be in Colorado. Is that correct, Mr. Cooper?
That's correct. Only here for the next couple days, Your Honor.
Okay. So if that's what you want as a defendant and Mr. Altenberg does not object, I will allow you to appear remotely for the trial. So let's go ahead and accept the not guilty plea. The charge here is launching or landing aircraft in violation of section 833 of the Boulder Revised Code. This allegedly occurred at 100 Flagstaff Road on September 7th of 2025. How do you plead to that charge?
I'd like to plead not guilty.
All right, I'll enter that not guilty plea now. and then we will set you over for trial. I'm assuming, we can't do a jury trial remotely. It can only be a trial to the court. So I'm assuming that's what you're.
That's acceptable, yeah.
Okay, so I'll accept the not guilty plea. We'll set this down for trial to the court. I'm going to authorize Zoom. Mr. Altenberg, can you file the motion for a remote hearing so that I can set deadlines for exhibits and things of that nature?
I'll be filing that shortly, Your Honor, probably the next hour.
Okay, that sounds great. Okay, so I've accepted the not guilty plea. We'll set you for trial to the court. I'm going to send you out front. The clerks are going to pick a date out there for you to set this for you. They'll give you a couple of options. It could be as far as 4 to 6 weeks out, only because our calendar's been pretty full. So they'll give you a date. You'll probably see an order that'll come out after Mr. Altenberg files his motion for remote hearing. I'll grant that. And then it'll have some deadlines. So if there are any kind of exhibits, photographs, or anything other than just you testifying that you want the court to be able to hear at the trial, you'll want to submit those according to what comes out in that order by the deadline that I set for that. And you'll want to submit them to our clerk digitally so they can upload them into our system. But that's the only thing I would point out for you. A basic process for a trial to the court. If you want to represent yourself, you're certainly fine doing that. I want to make sure you understand that you do have the right to hire an attorney, or if you couldn't afford an attorney, you could apply for the public defender. It's unlikely that I can appoint a public defender to represent you when you're not here in person for the trial. So I just want to give you that background. But if you're anticipating representing yourself during the trial, that's fine. If you hire counsel, it would have to be counsel that has a Colorado license. So it couldn't be someone in California. It looks like your home state is California.
That's correct.
So that can make things a little bit complicated for you, but I just want to make sure you understand if you're going to represent yourself, that's fine. But also know that the rules of evidence apply, the Colorado rules of evidence and this Colorado statutes apply. So you'll be held to the same standard as Mr. Altenberg is with respect to complying with those rules.
Okay.
If you represent yourself. Do you have any questions for me before we get you that trial date?
I think that all makes sense. I suppose when if I'm submitting evidence digitally, is that being seen by everyone beforehand? Is that like part of the discovery, or is that just something I'm entering in so that it's viewable on the Zoom call?
The latter, what you just described there. You'll be submitting it to a clerk. A clerk's going to load that up into our system. And so then I can't view documents until they've been admitted into evidence. And so there's a process. The prosecutor, for example, if he wants me to look at a photograph, he's going to have someone testify to what the photograph represents. That would be the same as for you. So even though you've submitted it to our clerks, doesn't mean I can consider it until you lay a foundation for me to consider it, saying this is a photograph of X area on X date.
Okay.
And then you could ask me to admit it. And any exhibit that you offer will have to be labeled as a defense exhibit. And that's usually defense exhibits A, B, C, start with letters, and the prosecutors will use numbers for their exhibits.
Okay.
Okay.
Understood. Thanks.
All right. If you don't have any other questions for me, I'll send you out front. They'll get you that trial date here in just a few moments.
Okay. Thank you.
You're welcome. Have a good day.